petitioner is a councillor, my lords. He is aggrieved by annexure P1, whereby, my lords, he as a councillor has been removed by the divisional commissioner. Now, the divisional commissioner has exercised his power under section 19(1)(a) of the Municipal Corporation Act. I'm challenging the P1 is the impugn order. I'm challenging the impugn order mainly on 3 grounds. Firstly, my lords, this is absolutely in the teeth of proviso to section 19(2) of the Municipal Corporation Act. Secondly, my lords, there is no application of mine. And thirdly, I'll try to persuade your lordship that this is a case of legal malice. For a moment, my lords, may firstly see 19(2) proviso of the Municipal Corporation Act. Section 19 reads,
Just a minute.
my lords.
ये पढ़िएगा provision.
My lords, the provision reads like this, my lords. Removal of councillors. The divisional commissioner may at any removed any elected councillor.
आप तो proviso पढ़ रहे थे ना?
Yes. Second is, my lords,
हाँ.
provide the. I also read section clause 2. The divisional commissioner may, while ordering the removal under subsection 23(3) or this section, also order that such councillor shall not be eligible to become a councillor of a corporation for a period which shall be specified in the order and which shall not exceed 5 years, provided that no resolution recommending the removal of any councillor shall be passed by the corporation, nor any such order of removal shall be passed by the divisional commissioner unless such councillor has been given a reasonable opportunity of showing cause why a recommendation should not be made for his removal or why he should not be removed from his office. Now, my main contention is there is no specific show cause notice.
अपील होती है 3 में तो
I'll just point out, sir, why appeal would not be an efficacious remedy.
जी.
My lords may firstly appreciate the act itself says that there has to be a specific show cause notice.
जी.
Now, the procedure adopted by the learned divisional commissioner is something which is alien to the act. What he does is
रिकॉर्ड बुला लेते हैं, नोटिस दिया था कि नहीं दिया था?
हाँ, notice नहीं दिया.
Page number 5 and para number 8 and 9.
जी.
Opportunity of hearing is already given and so called notice has been issued to the petitioner. They have filed their reply before the commissioner.
Para 8 and 9.
उन्होंने रेवेन्यू केस में दर्ज किया और उसमें हमने जवाब दिया. This is what my submission is.
नहीं.
That
notice कहाँ है? वो where is that notice?
My lords may come to P10 का जो हमें the only notice which I got.
P10 क्या notice?
61. My lords may see this.
हाँ.
The notice is under section 17 and it is registered as a revenue case. I gave my reply on the basis of the complaint of the complainant. I was not at all aware as to whether I would be removed or not. This is what my humble submission is.
उपयुक्त मामले की सुनवाई.
Yes, I appeared. I gave a reply also. That is all disclosed I have in the petition.
ठीक है, तो जाके अपील फाइल करिए.
My lords may kindly appreciate 19(2). My lords, it specifically says Gorkha Securities is directly on the point. Show cause notice must be very specific. Now here
What is the show cause notice?
there is no show cause. This is what I say. They have simply issued a revenue case notice.
क्या बुला लेते हैं इनका? देखिएगा भाई.
My lords may.
Petitioner's contention is that no show cause notice was issued in favor of the petitioner. Annexure P10 is a show cause notice under section 17 of the Municipal Corporation Act.
Under which only state government can issue exercise powers. Under 17.
देखते हैं.
My lord, may I only pray for stay, my lords.
नहीं, अरे.
My lords, prima facie I am trying to make out a case that as per the mandate of the act itself, there has to be a.
17 में कहाँ लिखा है कि नोटिस जो है सिर्फ वो दिया जाएगा स्टेट गवर्नमेंट.
My lords may come to 17. There are 2 different provisions. Under 17, my lords may come to 17 firstly.
हाँ, पढ़िए.
Yes. 17 is general disqualifications for becoming a council.
Yes.
1, my lords may come to the relevant provision 2.
हाँ.
Disability from continuing as a councillor if councillor during his term for which he has been elected or nominated A becomes disqualified. Say for example I am convicted. In that case I would be disqualified. For that my lords may come to then proviso.
They भी argue ये किया that notice under section 17 can be only given by the state government.
Yes.
Where is it mentioned that notice under section 17 will be given only by the state
For
government?
that for 17(3) may be seen.
17 पढ़िएगा.
Power to decide whether vacancy has
There are
occurred.
2 different things. once 17(1) and 2 eventuality takes place and an office is vacated, then it is notice कहाँ देगी सरकार आपको?
इसका मैं आपको क्लैरिफाई कर देता हूं. My lords, may appreciate the fact that under the Municipal Corporation Act, even if I am convicted, for that state government takes a decision whether I be continued or not. This gets clear from 17(3). Under the Representatives of People's Act, I am automatically disqualified.
आपको conviction के ground पे हटाया है
Yes,
क्या?
this is what my submission is.
You have been convicted
Yes,
by the court of law.
yes.
हाँ.
That judgment also I have placed on record. However, that would not be, at this stage, I can't agitate that ground. My submission is state government can only issue under 17. Though under 19(1)(a) there is public interest mentioned. Commissioner can definitely exercise that power. But fact remains there has to be application of mind and there has to be compliance of proviso to section 19(2).
वकील साहब इतना हड़बड़ी से काम नहीं चलेगा. You will not be able to get anything.
मतलब 17(3) may be seen firstly. Power to decide.
एक से रुक जाइएगा पहले आप.
Sir.
Submitted the other.
हाँ पढ़िएगा आप जरा 17(3) पढ़िएगा जरा थोड़ा सा देखते हैं इसको. धीरे धीरे पढ़िएगा 17(3).
Power to decide whether vacancy has occurred in every case except the cases falling under subclause N.
Clause नहीं, ये clause N है.
Clause N of subsection 1.
हाँ,
and
एक से रुक जाइए. Clause N किससे डील करती है? Clause N पढ़ लीजिएगा पहले.
I am not concerned with that.
You are not concerned with it.
I would not be covered with that.
हाँ, and even clause C of
Yes.
subsection 2 you are not concerned with it. Then how subsection 3 will be attracted?
It will be attractive once I am disqualified under 17(1)(a).
No.
My lords may kindly
It
appreciate.
specifically says, therefore I asked you to read, in every case except the cases falling under itna and itna, the authority competent to decide whether a vacancy has occurred under this section shall be
the
government.
Yes.
Vacancy automatic. Now the power of the commissioner under section 19 has not been taken away.
No,
For removal of a
19(1)(a)
councillor.
19(1)(a) may be seen then.
1A.
It is only in respect of public interest. It does not talk about disqualification on the ground of conviction. 19(1)(a) may be seen.
चलिए, if you want a finding, I can give you a finding that conviction amounts to consideration of public interest.
मतलब for that there must have been reasons assigned in
आप
the
ये
order.
डिसाइड कर लीजिए आपको 19(3) में अपील में जाना है कि यहाँ पर कंटिन्यू करना है पिटीशन.
With humble submission, I would like to argue this here.
हाँ चलिए बताइए.
मतलब.
Now let us
19(1)(a) my lords may come to.
19(1)(a).
My lords.
Now start 19(1)(a).
Yes. This is removal of councillors and the powers exercised by the commissioner under 19(1)(a).
जी.
Now, present is a case where commissioner has exercised power under 19(1)(a).
Yes.
The divisional commissioner may at any time remove any elected councillor. A. This is the subsection which has been exercised in my case.
जी.
If his continuance as a councillor is not, in the opinion of the divisional commissioner, desirable in the interest of the public or corporation.
जी.
This is what has been exercised.
जी.
Now, my lords, the genesis of the case is their complaint P2. My lords may come to directly P2.
P2.
This is two important aspects coming out from their complaint is they are seeking my disqualification under the 8(3) section 8(3) of the Representatives of People Act, which talks about automatic
Forget
disqualification.
about it. Representation of People Act, does it has any application?
No, this is what I say. Their
Forget
complaint
about-
is based upon
forget
that
about their
act.
complaint. Forget about their complaint.
Yes. My lords
The
may come
issue
to.
is whether you have been convicted or not.
I have been
Conviction
convicted,
is,
my
your
lords.
conviction is under which provision?
My conviction is 323, 324, read with 34.
323, 324, read with 34.
34.
हाँ.
My lords may come to P2.
P2 ही तो पढ़ रहे हैं भाई.
P2 में my lords may see firstly the very important aspect penultimate paragraph may be seen.
जी.
लोक प्रतिनिधित्व अधिनियम रिप्रेजेंटेटिव ऑफ पीपल एक्ट 1951 की धारा 8(1) व 8(2) के अनुसार सजा याफ्ता के चुनाव लड़ने एवं पद में रहने में आयोग करार दिया गया है. वही धारा 8(3) इसे 2 साल या उससे ज्यादा सजा होने पर व्यक्ति विशेष को आयोग करार दिया गया है. लोक प्रतिनिधित्व अधिनियम को नगर निगम अधिनियम में मान्य है, जिसकी पुष्टि के लिए छायाप्रति संलग्न है. अतः श्रीमान जी से निवेदन है कि लोक प्रतिनिधित्व सो एंड सो एक्ट एवं तत्समय प्रवर्तित अन्य अधिनियमों के प्रावधान के अंतर्गत सजा याफ्ता पार्षद सो एंड सो का तत्काल प्रभाव से निरस्त शून्य अनुसार घोषित किया जाए. What his prayer was to declare my election as null and void.
What आपका कितने साल का imprisonment है? Where is the order of conviction?
That is my lords P8.
P8
order of conviction.
कितने साल की सजा दी है आपको?
This is 2 years, my lords,
2 years.
and 1 year. It has been held that I have been convicted for 3 years.
हाँ ठीक.
Commissioner interprets in that manner.
नहीं ठीक है, 2 year and 1 year ठीक है.
Then, my lords, if my lords are going into the merits
एक second.
of the judgment, then my role also may be seen,
No, I'll not go into the merits of the judgment. I am not sitting here in appeal.
my lords. This is the judgment at page annexure P8. What I am trying to establish before my lords is, my lords may kindly appreciate for a moment.
जी.
The complaint itself was not maintainable. Genesis of the list was P2 complaint. He tries to invoke 8.3, which is not at all applicable.
ठीक है, चलिए हो गया और बताइए.
On the basis of his complaint, I gave a detailed reply. P4 is my reply. Now, I was never, I could not have anticipated, my lords, commissioner would exercise powers under 19(1)(a). This is what my submission is. And therefore, my lords, proviso to section 19(2) comes into effect
ठीक है,
and play.
ठीक.
Ideally, commissioner ought to have issued a show cause notice.
ठीक, समझ गया. रिपीट मत करिए की चीज को. और
So P4 is my reply,
जी.
which specifically says, page 24, P4, para 2 specifically says, my lords,
P4 जी.
यह है कि आवेदक गणों के द्वारा की गई शिकायत में लोक प्रतिनिधि पीपल्स रिप्रेजेंटेटिव एक्ट का उल्लेख करते हुए अनावेदक का निर्वाचन शून्य घोषित किए जाने की गई है, जबकि इस प्रकरण में लोक प्रतिनिधित्व अधिनियम के प्रावधान लागू नहीं होते हैं. दिस इज माय स्पेसिफिक रिप्लाई. फर्दर आई फर्दर stated section for declaring my election to be null and void, only section 441 of the Municipal Corporation Act would be applicable,
ठीक.
and not, my lords, merely a prayer in this manner.
ठीक.
Now, my lords may come to 2 judgments I'll rely upon.
जी 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 जी.
Firstly, my lords may come to, as regards alternative remedy. This would directly come to my rescue. Page para 15, my lords may kindly consider. If there is violation of act and provisions, para 15, my lords may come to. Thus, while it can be said that this court has recognized some exceptions to the rule of alternative remedy, that is where the statutory authority has not acted in accordance with the provisions of the enactment in question. This is what would be applicable in my case. Or in defiance of the fundamental principles of judicial procedure, or has resorted to invoke the provisions which are repealed, or when an order has been passed in total violation of principles of natural justice. So my submission is there would be 2 violations. One is violation of natural justice, and in defiance of the MC Act, he has acted.
ठीक.
So therefore, my lords, alternative remedy would not be a bar. Second judgment I like to rely is this, my lords. Gorkha Securities directly on the point that show cause must be, my lords, must have a proposed penalty in that.
Okay.
Para 21, my lords, may kindly see this. What must be the contents of the show cause? The central issue, however, pertains to the requirement of stating the action which is proposed to be taken. The fundamental purpose behind the serving of a show cause notice is to make the noticee understand the precise case set up against him, which he has to meet. This would require the statement of imputations detailing out the alleged breaches and defaults he has committed, so that he gets an opportunity to revert the same. Another requirement, according to us, is the nature of action which is proposed to be taken for such a breach. That should also be stated so that noticee is able to point out that the proposed action is not warranted in the given case, even if the defaults breaches complained of are not satisfactorily explained. When it comes to the blacklisting, this requirement becomes all the more imperative, having regard to the fact that it is the harshest possible action. My submission is, ideally, Commissioner ought to have issued a show cause notice despite receiving his complaint P2, which is not done in the case. He registered a case as a revenue case. I replied as per his complaint. I never had, and I could not have anticipated.
Don't repeat. आपका एक बार argument note कर लिया गया है.
Sir.
Repetition will not help you.
My lords. So these are, and as regards merits, my lords, lastly, I would submit.
जी.
Second ground is that of non-application of mine. Recently, Honorable Court has allowed the extenuating case on the ground where collector has merely mentioned कि मेरा समाधान हो गया है. My lords may kindly see the impugned order now. Nowhere he discusses the judgment. He merely says मेरा समाधान हो गया है.
ठीक है, चलिए और कुछ.
And thirdly, my lords, I have tried to make out a case of legal malice. P3 is the complaint, which P2 is the complaint. P3 is another complaint by the petitioner, respondent number 2.
एक legal malice हो गया.
My lords,
दूसरा.
that this is absolutely in the teeth of 19(2) proviso.
हाँ.
And thirdly, my lords, there is no application of mine.
चलिए.
At least he ought to have discussed the judgment.
ठीक है.
And as regards merits of the judgment is concerned, my role was merely holding a lathi.
ठीक. Anything
This is
else?
all. This is.
लिखिएगा. This petition is filed by the petitioner Sachin Kumar Bahare, being Sachin Kumar Bahare नहीं है ना आप? नहीं, sorry,
Sandeep Yadav.
sorry, by Sandeep alias Guddu Yadav, being aggrieved of order dated 9th October 2023, passed by the Commissioner Jabalpur Division, Jabalpur, in case number 0203 oblique appeal oblique 2023-24, whereby exercising authority in terms of the provisions contained in section 19 of the Madhya Pradesh Municipal Corporation Act 1956, petitioner has been declared to be disqualified to hold the post of the councillor in Nagar Nigam Katni.
Yes, my lords.
फैक्ट्स देख लीजिएगा, फैक्ट्स गलत ना हो.
Yes, my lords.
Nagar Nigam Katni, full stop. Impugned order is challenged on the ground, next para hai na? On the ground that a complaint was made against the petitioner by the private respondent, alleging that on account of conviction, petitioner has become ineligible in terms of the provisions contained in section 8 within bracket 1 and 8 within bracket 2 and comma and 8 within bracket 3 of the Representation of People Act, on being convicted for 2 years or more, and that being the complaint, petitioner had filed reply to that effect, that provisions of Representation of People Act are not applicable. But after registering a case as a revenue case, as is evident from Annexure P10, petitioner has been visited with the penalty punishment of removal. Full stop. It is submitted that there is no application of mind on the part of the commissioner, in as much as he has failed to appreciate that in the criminal case, allegation on the petitioner was only of wielding a lathi, and secondly, proviso below subsection 2 of section 19 of the Madhya Pradesh Municipal Corporation Act 1956 has not been considered in the right perspective. It is also submitted that it's a case of legal malice. Full stop. Reliance is placed on the judgment of Supreme Court in Commissioner of Income Tax and Others versus Chabil Das Agrawal 2014 का एक SCC 603. Full stop. Placing reliance on this judgment and drawing attention of this court to para 15, it is submitted that there cannot be an insistence to avail alternate remedy because Supreme Court has recognized some exceptions to the rule of alternate remedy, that is, where the statutory authority has not acted in accordance with the provisions of the enactment in question, comma, or in defiance of the fundamental principles of judicial procedure, comma, or has resorted to invoke the provisions which are repealed, comma, or when an order has been passed in total violation of the principles of natural justice. Full stop. Next para. Similarly, reliance is placed on the judgment of Supreme Court in Gorkha Security Services versus Government within bracket NCT of Delhi bracket close and others 2014 का 9 SCC 105. Full stop. Placing reliance on paragraph 21 and 22 of the said judgment, it is submitted that show cause notice should have given the consequential action which was required to be taken by the commissioner, but since notice annexure P10 is silent on this aspect, therefore petitioner could not have been declared to be disqualified from holding the post of the councillor. Next para. Shri, it is submitted that appropriate opportunity of hearing was not afforded to the petitioner. Next, Shri Mohanlal Sharma, learned counsel for the respondent, in his turn submits that notice was given to the petitioner as contained in annexure P10. That notice was sufficient and petitioner had filed his reply vide annexure P4. After giving him opportunity of hearing, Commissioner has passed impugned order annexure P1. Next paragraph. After hearing learned counsel for the parties and going through the record, before adverting to the orders of the Commissioner, comma, provisions contained in section 17 within bracket 1, another bracket Roman 2, another bracket small a are relevant for the controversy. Full stop. This provision provides that this section deals with general disqualifications for becoming a counselor. Full stop. It is provided in subsection 1 bracket में Roman 2 another bracket small a that a person who has been convicted by a court in India for an offence not falling under subsection 1 and sentenced to a imprisonment for a period of not less than 2 years is disqualified. In the present case, it is admitted that white judgment कहाँ है annexure?
P8.
White judgment dated दो पेज लगा दिया आपने लास्ट के
No. The entire judgment is filed. P8 my lord.
जजमेंट की डेट क्या है
28/12/22.
28/12/2022 petitioner has been convicted under section 323 324 read with section 34 IPC for a term of imprisonment of 2 years RI for conviction under section 324 and 1 year RI for conviction under section 323 by the Court of Learned 5th Additional Session Judge Katni. Next paragraph. This fact is borne out from annexure P8. Next paragraph. Section 17 within bracket 2 deals with disability from continuing as a counselor and reads that if any counselor during the term for which he has been elected or nominated becomes disqualified under subsection 1 of section 13 and his name is struck off or under subsection 1 of this section, then he shall be subject to the provisions of subsection 3 be disabled from continuing to be a counselor. Next para. Section 19 deals with removal of counselors. Full stop. Divisional Commissioner has been empowered to remove a counselor for the eventualities given in subsection 1. Full stop. Subsection the clause A, clause small a bracket के अंदर of subsection 1 of section 19 provides that a person will be liable to be disqualified and for removal if his continuance as a counselor is not, in the opinion of the divisional commissioner, desirable in the interests of the public or the corporation. Full stop. Next para. Subsection 2 of section 19 authorizes the divisional commissioner that while ordering the removal, he can also pass an order declaring the said councillor to be ineligible to become a councillor of a corporation again, which period shall not exceed 5 years. Next para. Proviso below subsection 2 of section 19 on which lot of emphasis is laid by Shri Utkarsh Agrawal deals with the fact that no resolution recommending the removal of any councillor shall be passed by the corporation, nor any such order of removal shall be passed by the divisional commissioner unless such councillor has been given a reasonable opportunity of showing cause why a recommendation should not be made for his removal or why he should not be removed from his office. Next para. Admittedly, notice annexure P10 though contains heading of Rajaswa Mamlo mein notice but is passed by the commissioner in terms of the provisions contained in section 17 of the Municipal Corporation Act 1956. Full stop. Thus, when this aspect is taken into consideration, then it is evident that section 17 of the Madhya Pradesh Municipal Corporation Act 1956 deals with the disqualifications which may be earned by a councillor. Full stop. Since section 17 1 in another bracket small Roman 2 bracket close another small bracket small a provides for a disqualification on being sentenced to an imprisonment for a period of not less than 2 years, comma, commissioner was not required to adjust the merits of the judgment of the criminal court as that is the special prerogative of the appellate court and not of the court of the commissioner. Thus, once there is a conviction, then there is an attached disqualification with consequences, and since the consequences are that a councillor becomes disqualified, then he will be disabled from continuing to be a councillor or mayor and his office shall become vacant. Full stop. In the present case, commissioner, after affording opportunity of hearing where petitioner admittedly could not dispute his conviction for 2 years or more, has exercised his power. Therefore, second submission that in terms of proviso to section 19(2), petitioner could not have been removed as no reasonable opportunity was given is not made out. Even aspect of non-application of might is also not made out. Full stop. Judgment rendered in case of Gorkha Security Services Supra has limited application in as much as that was a case of blacklisting. Authorities entitled to pass an order of blacklisting had several options available to them. But in the present case, once a disqualification is earned on account of conviction for 2 years or more, then there is no other option but to remove. And once notice was issued under section 17 of the Municipal Corporation Act, then the consequence was well known to the petitioner, except he would have proved that his conviction has been stayed by any superior court. Full stop. Therefore, Gorkha Security Services has no application to the facts of the present case. Next para. Similarly, law laid down in case of Commissioner of Income Tax and others versus Shabil Das Agrawal has no application to the facts of the present case because rule of availing alternate statutory remedy can be waived only when petitioner is able to demonstrate that there is defiance of the fundamental principles of judicial procedure. Full stop. No such material is brought on record to substantiate first ground. Second ground which is available as per Shabil Das is that reliance is placed on a repealed judgment or in violation of principles of natural justice, that too is not made out. A notice was duly issued under section 17, reply was called, opportunity of hearing was given, and therefore even judgment of CIT versus Shabil Das has no application to the facts of the present case. Next para. As far as third ground, in regard to legal malice is concerned, comma, whenever malice either of fact or law is alleged, then it is incumbent upon such person alleging malice in legal malice to implead that person against whom legal malice is alleged. In the present case, petitioner has failed to implead divisional commissioner in his personal capacity. Therefore, he could not have waived the requirement of alternative statutory remedy as is provided in subsection 3 of section 19 of the Madhya Pradesh Municipal Corporation Act 1956. But since petitioner insisted to have a judgment on merit instead of accepting suggestion of this court to avail alternative statutory remedy, comma, that right to avail remedy is hereby closed because after judgment of the High Court, a subordinate authority in the state government cannot be allowed to sit over the decision of the High Court and scrutinize the same in the name of appeal. Full stop. Therefore, petitioner has voluntarily given up his right to avail remedy of appeal as is provided in subsection 3 of section 19 of the Municipal Corporation Act 1956. Next para. As far as merits of the case are concerned, conviction for 2 or more years has natural corollary of declaring a person to be disqualified to hold the post. Full stop. Therefore, action taken by the commissioner, which is a natural consequence and for which commissioner had material as contained in clause A of subsection 1 of section 19 of the Act of 1956, there is no illegality in the impugned order calling for interference. Petition fails and is dismissed.
I would only pray that insistence part, my concession may not be recorded.
Which concession?
Honorable court has observed, I myself has voluntarily,
You have? I gave you offer. Sorry. Now that
can have it on the merits, but the difficulty would be,
no liberty can be given. I have explained.
I'm not seeking any liberty. My lords may has on merits dismissed it. I neither want any kind of liberty, but that observation is coming against me. That's all.
No, आने दीजिए. Because I had offered you in
No,
first
I'm
place
not.
that there is an
Neither I would pray
alternate
for
remedy
liberty, my
available.
lords.
Sorry. You said that you want an
No,
order.
but that insistence and
I'm sorry.
observation would be.
I'm sorry.